On Maslaha, Malah, literally welfare, public interest, is viewed as a fundamental goal of the Sharia and by some schools of Islamic law as an independent source of law, because it involves the potential for friction between the dictates of the Quran and the Sunnah on the one hand, and what is perceived at various times as public interest on the other. Discourse on Malah has long been characterized by tensions between reason and the authority of revelation. The Oxford Encyclopedia of the Islamic World, edition John Esposito, 2009. المناسب ما تقع المصلحة عاقبة. قال في الروضة: ومعنى المناسب أن يكون في إثبات الحكم عاقبه مصلحة. شرح الكوكب المنير باب القياس مسلك العلة الرابع من مسالك العلة المناسبة. One way of identifying a reason for the laws is that a maslaha is discerned within that reason. Something is a reason for the law if the law, because of it, fulfills a maslaha. ومن تتبع مقاصد الشرع في جلب المصالح ودرء المفاسد حصل له من مجموع ذلك اعتقاد أو عرفان بأن هذه المصلحة لا يجوز إهمالها، وأن هذه المفسدة لا يجوز قربانها، وإن لم يكن فيها إجماع ولا نسخ ولا قياس خاص فإن فهم نفس الشرع يوجب ذلك. ومثل ذلك أن من عاشر إنسانا من الفضلاء الحكماء العقلاء وفهم ما يؤثره ويكرهه في كل ورد وصدر ثم سنحت له مصلحة أو مفسدة لم يعرف قوله فإنه يعرف بمجموع ما عاهده من طريقته وألفه من عادته أنه يؤثر تلك المصلحة ويكره تلك المفسدة. ولو تتبعنا مقاصد ما في الكتاب والسنة ولعلمنا أن الله أمر بكل خير دكه وجله وزجر عن كل شر دكه وجله. وإنما الإشكال إذا لم يعرف خير الخيرين وشر الشرين أو يعرف ترجيح المصلحة على المفسدة أو ترجيح المفسدة على المصلحة أو جهلنا المصلحة والمفسدة. ومن المصالح والمفاسد ما لا يعرف إلا كل ذي فهم سليم وطبع مستقيم يعرف بهما دق المصالح والمفاسد وجلهما وأرجحهما من مرجوحهما، وتفاوت الناس في ذلك على قدر تفاوتهم فيما ذكرته، وقد يغفل الحاذق الأفضل عن بعد ما يطلع عليه الأخرق المفضول ولكنه قليل. وأجمع آية في القرآن للحث على المصالح كلها والزجر عن المفاسد بأسرها قوله تعالى: إن الله يأمر بالعدل والإحسان وإيتاء ذي القربى وينهى عن الفحشاء والمنكر والبغي يعظكم لعلكم تذكرون. النحل 90. فإن الألف واللام في العدل والإحسان للعموم والاستغراق، فلا يبقى من دق العدل وجله شيء إلا إن درج في قوله إن الله يأمر بالعدل. النحل 90. قواعد الأحكام لابن عبد السلام جيم 2 315. دار القلم نزيه كمال حماد شرطة 2000 الكليات الأزهرية طه عبد الرؤوف سعد 1991. Identifying the maslaha God wants humans to pursue is accomplished by getting to know God enough to know what God would want you to think or do in a certain situation, even with no revelation found to indicate it. When you know how a good man thinks, you have the tools to guess what he would prefer in a given situation, even if you didn't have explicit knowledge that he actually did or said anything specific about it, but you would know it because you knew that person. Introduction. Maslaha may be a particularly unlucky term. It is very hard to translate. The Arabic word should invoke a sense of the good, something to be pursued, something beneficial, and that which is in your or someone's interest. If we go for the good, conjuring up the commonly traded statement where maslaha is found, God's law is found, we fall into an empty tautology. Interest, well-being, and welfare also have their limits. The success of one rendering over another always depends on how the English sentence is built. The scope of the term, with Muslim jurists being comfortable with expressions such as the clash of masali, must be sized to fit in the sentence in which the term appears. And there's an added burden. What makes maslaha doubly unlucky, next, perhaps, only to maqasid, is the frequency with which it is invoked by contemporaries to solve problems of modern Islamic moral and legal reasoning. With a limited number of tools of this kind, one could spend their free time engaged in the magic of evaluating conflicting interests or benefits or goals to enter a decision about what Islamic legal and moral reasoning is bound to say about a modern question of a complicated nature. Some major Muslim jurists have denied applying maslaha reasoning, also known as istisla, mobilizing maslaha, but have, in fact, used it in a section which, curiously, discusses maslaha analysis as an imaginary source of the laws, min al-usul al-mawama. In his theoretical jurisprudence compendium, al-Mustasfa, Abu Hamid al-Ghazali, d. 505/1111, argued that eliminating a human shield at the front of an invading, hostile army is justified, nay necessary, given a calculation in which our side may lose one, the shield alone, or two, both the shield and soldier and civilian populations. Ghazali, in other words, does not call this a form of maslaha reasoning, but this is how he justifies his argument, which seems indistinguishable from a normal maslaha argument. Killing the innocent, the shield, he says, is impossible to directly justify, but the result that this contingency of innocent Muslims is eliminated shows up on both sides in a broken equation, where on one side only the shield is eliminated, and on the other they are joined by additional soldier and civilian populations. Only on one side the invading army is repelled, and more people are saved. The maslaha calculation, which Ghazali declines to call it by its name, istisla, is not necessarily my interest versus your interest, or the interest of my group versus the interest of your group. There are conflicting claims to a better conclusion, which cover the whole condition under consideration. It is true that the Muslim jurist is concerned with Islam as a religion and the Muslim population that bears its symbols. But within that, what is at work is not a simple utilitarian calculation of here lies the interest of the majority, or this group is more valuable than the other, even if it is not a majority, or this law fulfills the interests of a larger number. There are claims, and the jurists assess them, having made only a commitment to serving a purpose the jurist thinks God aims to fulfill, as the text by Al-Izbi, Abd al-Salam on pages 3 to 4 indicates. In this and other examples, maslaha analysis, if or when it is called something else, requires securing two elements, a hierarchy of priorities and a confirmation of presumptive facts. In the human shield question, Ghazali takes the survival of a larger part of the Muslim community to offer a higher degree of value and hence deserve prioritization over the survival of a smaller group of them. This, as he says, is something of a mathematical exercise, less versus more, or value X versus value X plus. The presumptive facts are that failure to eliminate the human shield ineluctably yields an elimination of both the shield and an added number of the population. Both elements must be conjured up in mind when we answer this and other questions. One may argue, for example, for granting prison inmates conjugal visits, family overnight visits, in order to A. Allow the inmate to keep a strong bond with his family, B. Allow the spouse to also have a quasi-normal relationship with the incarcerated spouse, and hence C. Reduce recidivism, since strong family bonds weaken the chances of resuming a life of crime after punishment. This analysis must include an examination of the above two elements, that a decision based on it protects the higher value and that the facts presumed in the analysis be correct. If, for example, it turns out that recidivism is unaffected by the permission of family visits, that families collapse during the imprisonment of one spouse regardless of how prison administrators deal with the families of the incarcerated, or that these families collapse right after the end of a prison sentence in most cases, then the argument for family overnight visits to keep families intact and reduce recidivism fails. Thorny as the matter may be, we would like to work out an assessment of how the term has consistent overlaps with the legal terminology of other legal traditions and how it seems to be seen differently by different masters of the Islamic legal traditions, whether or not we agree with them. This essay is divided into 5 segments. The first offers a straightforward standard for the inevitably comparative framework by which one may speak about Maslaha in an Anglophone garb. This segment also declares our interest as a field of application in the rights of prisoners and the reasonableness of a utilitarian calculation leading to how prisoners are treated in our time. The element of texts of the divine revelation is part of how Maslaha is discovered and argued, how analogical reasoning is employed to support it, and how conclusion and its opposite may be argued based on the standard of Maslaha. In this first segment, the pre-modern voice of Ibn al-Qayyim, no mean authority, brings with him a ready debate. The second segment continues the debate by introducing more foundational standards, drawing on a jurist of the 511th century, who never disappoints when consulted on the very basis of laws and why they are the way they are. This is Abu al-Ma'ali al-Juwayni, d. 478/1085. The third is a journey in the company of his al-Din ibn Ibidi al-Salam, d. 660/1262, a 7th-13th century Shafi'i jurist who reduced the whole system of laws to observing one and the same principle with a Janus face. On the one end, it is avoiding harm, or the lesser of two harms. On the other, it is pursuing Maslaha. The fourth segment adds even the more significant voice of Najm al-Din al-Tufi, d. 716/1316, a daring jurist who understood the art of jurisprudence to be the ability to identify that which needs to be protected at all cost. That is the Maslaha, which is so valuable, so important, and so representative of the goals of the laws of God that even the apparent language of the revelation would be deemed secondary in importance to it. When they want to dismiss him, his foes bring him up as the man who forgot the primacy of the revelation and asserted that when text and genuine Maslaha compete, the latter is bound to trounce the former. The fifth segment then moves us to the modern genius of Abd al-Razak al-Sanhuri, 1391/1971, and how he conceived of the Maslaha worthy of protection and haq as one and the same, being the privileged position occupied by those who are owed something by others, a debt or an obligation of sorts. Whatever language a lawyer or jurist may elect to choose to express this debt or obligation, other jurists show up occasionally to play the role of supporting characters. There are once again 2 semantic spaces for the term Maslaha. On the one hand, there's your Maslaha in mind, possibly your interest in mind. This is where a clash of masali is not hard to imagine. A clash of masali is also easy to imagine without any reference to personal interests. On the other hand, there's an aggregated Maslaha, or a condition of balance of worthy considerations, which can be taken as a basis for a decision by a jurist. This is not necessarily an ideal or an otherworldly condition. It is, however, that which is preferred to all alternatives. This is where one may say that God's law is found where the aggregated Maslaha is found. Analogously, Muslim jurists speak of conflict of sources of the law, then talk of a reconciliation of these sources. The legal language one uses shapes, and sometimes facilitates, in many ways, one's conclusions. Much of the innovation in modern Sharia jurisprudence, for example, is ultimately tethered to the invention of new terminology. In the hand of modern Sharia jurists, the word hukm was divided multiple times. The term proliferated into a large basket of subcategories. This allowed these jurists not only to speak of the traditionally accepted normal and emergency laws, but also to add sometimes confusing or more charitably elastic terms such as ahkam walawiyya or wala'iyya, roughly government rulings, which may overlap with emergency laws, but may also be distinct from them. The aim of the laws is always the same. They're meant to bring about balance in human affairs. But the question is which authority holds priority over others. When an application of this distinction and serviceable terminology grants the authority at the top of the legal and moral hierarchy the capacity to destroy mosques and suspend the duty of pilgrimage, one must realize that this authority is formidable. Not that conclusions such as destroying mosques or suspending pilgrimage, e.g., in war, are impossible to arrive within Sunni laws. It is that the language of the jurist here does pave the way for the accomplishment of goals otherwise unachieved without the excessive straining of words. This is not unlike how Abd al-Razak al-Sanhuri, d. 1391/1971, sidestep a debate between advocating utilitarianism and faith in essential and unalienable rights by employing clearer terminology that reduces rights to Maslaha. It takes a jurist, though, not a mere lexicographer, to do that. 1. Utilitarian calculations. Modern moral philosophy, even outside the lands of utilitarianism, is broadly utilitarian. That is, modern moral reasoning is usually based on a calculation leading to an identification of some overall preferred condition at the cost of ignoring any principled commitment to rights, including the right to life. When in doubt, think of all justifications of contemporary atrocities based on the fears that things can always get worse. This style of moral philosophy is also consequentialist. It rejects Immanuel Kant's deontic morality, where lying is always, always bad, even to save one's mother, as stiff and unrealistic. But what is wrong with that? This is a genuine, not a rhetorical, question. When examples are considered, other layers of theory will have to be introduced. Let's take punishments in the U.S. criminal justice system, which are mostly punitive, rather than reformative. What is behind these punitive practices? We need to put criminals away, and this may be because we are ultimately retributivists. We believe, with Kant, it might turn out that one must be punished for her or his own crime, regardless of whether the punishment contributes positively or negatively to reducing crime in the future, opposite the direction deterrence theorists, who are more purely utilitarian, would have us want to sail. Kant thinks it makes no sense for me, say, to be punished this or that way, so that the society benefits from the punishment, which deter others from committing a similar crime. Because what is just is that I be punished for what I did, and that is that. This is not, however, why we have extensive and expensive prison complexes in the United States. We have these because they give us comfort that those inside won't harm anyone, and those outside would be terrified to be in their place. It is in fact a utilitarian calculation, although, as we will see, not a perfect one. The argument for the current, less than humane, system of punishment must stand on two legs. 1. A subscription to a certain brand of psychology. Some of us are simply criminals, and Robert Sapolsky's science confirms this wholeheartedly. And 2. An appeal to the limits of our options. We just don't have the resources needed for a better treatment of the incarcerated. The consequentialist utilitarian won't stop at justifying the imprisonment of felons. She goes further to offer advice on how these prisoners are to be treated. The desires of an incarcerated person, they advise, are only accommodated when we have the time, energy, and resources. Hence, basic sexual needs, for example, are rarely accommodated in prisons and jails. See Appendix 1. Again, what is wrong with any of that? Well, to be honest, we are still thinking about it. One can say that the punishment of criminals in the U.S. may not be that consistent, even with the commitment to doing the best that can be done in terms of materialist utility, let alone with the notion of basic rights. That said, we would like to introduce other forms of utility calculation, hoping this might enrich our discussion. The most interesting aspect of utilitarian tests is their surprises. Just as utilitarian and consequentialist reasoning can lead us to cruel conclusions, they can also take us to embrace strange degrees of license. A strange type of license, in the following example, is given by a religious scholar from the Middle Ages, the Islamic Middle Ages, if these be real, against Thomas Bauer's well-known scorn of calling any non-European society medieval. This 14th century scholar was both a textualist and a consequentialist of a non-pure type, utilitarian. To explicate his peculiar view on the matter of whether one may lend his own wife to spend a day with another man to possibly save this person's life, Ibn al-Qayyim needed to lean on a 7th century precedent. The precedent. We are at the end of the first half of the 7th century, Islam's first. A man named Nasr b. al-Hajjaj, an unusually attractive man, is allowed to have a day of limited sexual pleasure with the wife of another man, one named Majashi b. Masudi. The three were close acquaintances, and in this love triangle, Nasr was in love with Majashi's wife and oblivious, at first, to the latter's suspicion that this was going on. The story goes that when Nasr learned of Majashi's awareness of the mutual attraction between his wife and Nasr, he withdrew from all social interaction and became dangerously ill. The license to give Nasr a day of soft sexual pleasure was given by Majashi himself, against his wife's protestation. The interpreter. Now we move to the 14th century juristic discussion and the rationalization of this license by Ibn al-Qayyim, d. 750/1351, of Hanbali law fame. Ibn al-Qayyim writes, someone may ask, does Sharia permit such a thing, allowing the lending, albeit briefly, of one's wife to another in order to save that person's life? I would venture the following answer. If it were the only way of treating someone's illness, it would not be that much worse than allowing a female doctor or nurse to offer medical treatment to a male patient, or the handling by a medical doctor of the body of a male or female patient AS for treating a person with sexual intercourse. Sharia does not permit it in any way. As for treating a person with hugs and kisses, if healing is achieved through them, it is similar to offering liquor as medicine for those who permit it. Indeed, this is easier than offering liquor as medicine, since imbibing alcohol is a major sin, while this act, hugs and kisses to a non-spouse, is a minor sin. And it is an act of kindness, and it has been an accepted tradition, Sunnatun Medea, to be merciful to lovers in deep stress. In Ibn al-Qayyim's reasoning, one is dealing with a marriage of textualism and consequentialist utilitarianism. The Quranic term lamam, Q53:32, indicating a peccadillo of sorts here haunts Ibn al-Qayyim, as he approaches how one looks into prohibited, limited sexual pleasure. Said verse strongly prohibits garf sins and abominations, kabayar, fawahish, but accepts lamam. The term lamam indicates essentially soft sex. Two analogies are drawn between the case under consideration and other cases. If soft sex is measured against medical treatment, which includes the handling of the private parts, vaginas, breasts, etc., it ought to be allowed when need requires it. If it is scrutinized by juxtaposition to offering an intoxicant as medicine, it is also allowed for those jurists who allow it. Only sexual intercourse is out of the discussion. One type of utilitarianism. There is then a form of medieval utilitarian, Maslaha-based, legal reasoning that takes the form of a calculated consequentialism. This is by no means limited to Hanbalis. But, to be sure, there are no pure consequentialists in Islamic legal reasoning. There are always moments of non-negotiable adherence to principles, which, as you see in the above analysis, Ibn al-Qayyim puts at the border of sexual intercourse. This is something of a review of what was said in the introduction. Maslaha indicates legally and morally sanctionable utility. Istisla, or weighing competing types of maslaha, aims to extract an algebraic calculation of utilities expressed in the form of an imbalanced equation. This is a benefit-benefit rather than a cost-benefit analysis. The equation needs to be imbalanced or broken. That is, one needs to arrive at a relationship between two action options in which one employs the symbol greater than as opposed to equals equal. If the calculation of utilities leads to a balanced equation, the jurist will fail to decide the case. But if a greater than sign relationship is found and can be employed to describe the case, the jurist will decide the case by taking the conclusion from the side that seems to offer the greater overall utility. How does this Maslaha test work in the so-called shield question, Tataris? In a war in which one must either 1. Eliminate a shield of captives made of civilians and soldiers from one side, or 2. Lose the war, one is advised to eliminate the shield, despite the fact that this involves the taking of innocent life, given that the alternative is potentially a loss of both the human shield and the war, leading to unspeakable death within army and civilian ranks. The benefit-benefit analysis is expressed thus. Winning the war, even at the cost of losing the human shield, carries greater benefit than protecting the shield, which might ultimately be a temporary and unsustainable benefit. Eliminate human shield plus win the war, lose the war, hence lose human shield and more. Textualism. What is the lalam in the Quranic verse 53:32 that haunted Ibn al-Qayyim as he made his Maslaha calculation in the above view? Perhaps one more story won't hurt. This being sourced out of the questionable Muqaddal Sulayman exegesis. The verse, it is said, was revealed to the Prophet of Islam after a man named Nabhan, the date seller, sexually assaulted the wife of an absent soldier, touching her buttock with his hand, but failing to rape her, which he might have had she not reprimanded him and escaped. The lady has been in need of food, a fragility that led the assailant to attempt to take advantage of her in his grocery store. An angry Umar b. al-Khattab, reminding those present that the soldier was out exposing himself to death for the sake of the group and entrusting them with his wife's safety and well-being, jumped on the man and suggested his execution to the Prophet. The verse, hence, came to establish that a touch on the buttock is, indeed, forgivable, as it qualifies as lamam. Scholars discussed this term in detail in diverse literature, from Quranic exegesis to lexical commentaries to legal manuals, and they differed on the concept of lamam. Their opinions can be summarized as follows. What is meant by lamam is the sin and immoral acts committed by the companions during the pre-Islamic era, such as disbelief in God, adultery, and theft. In other words, sins preceding coming to Islam, for those born before they embraced the faith. Lamam indicates minor sins, such as kissing, hugging, touching a woman, and any foreplay between unmarried man and woman, not including explicit sexual intercourse. Lamam is a sin for which the laws of Islam do not specify a punishment in this world, which also does not deserve punishment in the hereafter. Lamam is when a person commits a sin once and then repents, regardless of whether the sin was minor or major. Lamam refers to the thoughts of the heart that do not actually turn into a sin. The view of the majority of the companions of the Prophet and most jurists and Quranic exegetes, supported here by Ibn al-Qayyim, is the second opinion. That is, lamam indicates minor sins, such as kissing, hugging, touching someone of the opposite sex to whom an individual is not married, and, in short, any foreplay between unmarried man and woman, not including explicit sexual intercourse. Ibn al-Qayyim examined both the sources of the above 5 views, which authorities held each one, and their consistency with other legal doctrines of the law, we presume his own madhab, or school of law. This favored view is also that of several prominent interpreters, Ibn al-Qayyim reminds us, such as Ibn Kathir. What is the benefit of this textualist bent? It is supposed to offer a ceiling to maslaha reasoning. In other words, when in doubt about the hierarchy of values within any maslaha calculation, we consult the text of the Quran and the Prophet's Sunnah. The text will tell us what not to compromise on. Considering lamam, e.g., kissing a non-spouse, to be a light matter, one must note, is hardly the way of pious textualists. Authors such as Ibn Hajar, with his abundant sources behind him, warn with a bright red light that, in reality, no crime against God's order is a small matter. Appendix 1. Exceptions to the textual-based principle that one may not be seen alone together with a stranger in a khalwa condition, however, are also made based on texts that introduce the notion of necessity. We learn, for example, that the Prophet's wife Aisha was accompanied by one man when she was lost and her ride was non-functional. What is the cost of this textualist bent? A textualist bent may be sincere, where the textualist limits himself by the texts against his own personal preference, and it may be an artificial ex post hoc appeal to a text that fits the rational mold of the textualist. The problem is that texts are not consistently intelligible. If we imagine that severe punishments must be assigned to major violations of God's laws, we are up for a surprise. There are major violations of the law, e.g., bad manners with a parent, uqqa walidain, that are not punished at all. Ibn al-Qayyim's 2 analogies. Ibn al-Qayyim's ostensibly jarring conclusion is that one man may lend his wife to a lover for a short time to save this lover's life, or perhaps offer one instance of pleasure before this lover's demise. The discussion relies on two analogies with decisions that are broadly accepted in Islamic legal reasoning. The law that allows imbibing prohibited substances, if needed as medicine, and the otherwise prohibited handling of the private parts in the bodies of strangers, if needed in medical treatment, should not be scandalized or appalled when led to allowing a brief act of mercy by a spouse to a former acquaintance. Or should it? Is there a difference Ibn al-Qayyim is ignoring? A difference, perhaps, rooted in a human nature, again if such a thing be real, and be a basic human right both Najashi and his wife are thought to have exercised or given away by consenting to a visit of care for Nasser, regardless of what might come out of it. Let's take human nature first and inquire about Ibn al-Qayyim's commitments in this area. Does human nature play any part in Ibn al-Qayyim's reasoning? Would Ibn al-Qayyim go as far as to say that a woman, for example, may give her body to a coercer who wants sexual intercourse as a price for necessary water or food? Would he give this license to a man, i.e., allow a man to be sexually objectified to save his own life? Your body or your life? In Al-Turiq al-Hukmiyah, Ibn al-Qayyim confirms the worst of our suspicions. He does, in fact, go so far as to say that a woman may allow a stranger to have sexual intercourse with her if she feared death out of thirst. His argument is a bit shaky, if you ask us. The story on which he relies goes as follows. Umar b. Al-Khattab is presented with a confessing adulteress. As he prepares to mete out her punishment, he is told that she gave herself to a man who stipulated this sexual encounter as a price for water she desperately needed. She is coerced, Ali b. Abi Talib declared, and hence must be spared the punishment. Ibn al-Qayyim pushes this conclusion, not only to offer us an exception in the realm of criminal justice, whereby a license after the fact gives the judge a chance to forgive a defendant, but makes of it a general license, which seems to neutralize any commitment to a duty of chastity for indigent ladies. The even more questionable conclusion Ibn al-Qayyim makes is that he does not extend this license to a man propositioned to be a passive party in homosexual sodomy. Death is preferable for a man, he asserts, to life after being raped. A man who lets himself be sexually objectified will have been corrupt, he says, in his soul, heart, reason, morality, and honor. One thing is for sure, Ibn al-Qayyim is still an arrows shot away from a materialist who equates a person with a person's body. What if we disagree with Ibn al-Qayyim and say that a man may be excused for keeping his life at the cost of the humiliation brought about by sexual objectification? A man, in some cases, may need to stay alive to feed desperate children by any means necessary. Would we still have a distance to claim as a separation between us and true materialists? Near absolutes, consent, the right to procreate. Ibn al-Qayyim's textualism was expected to push him to identify his bottom line, where he has non-negotiables or near absolutes. And the Quranic text discussed above assured him that sexual acts below the level of intercourse may be a possible space for license, depending on what these violations of the law and their violations of the law are up against. What Ibn al-Qayyim said about licensing destitute ladies to offer their bodies to save their lives, however, left us unsure as to what the bottom line was, other than an act that left life itself unlivable after it. Are other legal traditions clearer about where they draw the line at which one will have touched a non-negotiable or an absolute right? In American law, someone's decision to offer their body for the sexual entertainment of another is a personal matter left to this person's consent, barring a rescinding of or confusion about the extent of the consent, and barring instances of violation of the public order. BDSM, the umbrella acronyms for sadomasochism, standing, last we checked, for bondage, discipline, sadism, masochism, is mostly legal in the US, but is more accurate to say that it is allowed in some jurisdictions in the United States and not in others, given how the interpretation of the laws by law enforcement tends to be a bit elastic. The federal law is certainly silent about it, and the anti-BDSM decision by the New York Supreme Court in People v. Yovanovitch, 1999, appealed, repealed, and retried, 2001 then dropped, remains an ambivalent and rare precedent. We here move to the realm of arguments from rights, not a balance of interests, though again, not absolute or consistent. Founding an argument on a notion of a basic right, consent in the case of BDSM, may cancel any invocation of the interest of the public or other private parties. Well, let's take it seriously for a moment. One has a basic right to their own body to use for the sake of attaining even perverse pleasures. Two basic rights may be at work here. It seems that a human's need for sex, not unlike their need for food, is so basic, and simultaneously the human has pure sovereignty over their own bodies, even when all object to how the person uses her or his body. But is it the basic right at work, or, more likely, a degree of comfort with libertiness, which is embraced by modern American law and society? If sex and food were not really distinguishable in that they fulfill basic human needs, would not allowing prison inmates access to consensual sexual action with consenting partners be protected as a basic right? The argument from basic rights carries no further burden of analysis. If the argument is made for pragmatic reasons, i.e., allowing conjugal visits is a way to keep an inmate connected to her or his family, so as to reduce the chances of total isolation from society, which adds to the chances of recidivism, then confirming the factual presumption is necessary for the argument. Unfortunately, studies have shown that marriages don't survive the incarceration of one of the spouses at high rates, and those marriages that survive an imprisonment sentence do collapse after the imprisonment ends. True, the causal link is not easy to articulate. That is, it may be that the same people who cannot keep a healthy marital relationship are prone to commit criminal acts, and it may be that incarceration destroys otherwise workable relationships. One might also note that the European Court of Human Rights seems to think that allowing a prison inmate to at least impregnate a spouse via artificial insemination should be guaranteed. This was stated in Dixon versus UK, and this 2007 European Court of Human Rights decision started to have reverberations. One of these, most recently, 2025, was a decision by the second highest authority in Egyptian administrative courts, asserting the same principle. In these decisions, needless to say, the questions involve no third parties, other than the government administering correctional facilities, prisons, or jails, as opposed to a human being whose consent may be needed to alleviate someone's suffering that is caused by sexual deprivation. A lot to think about. The questions that surround an inquiry on how Maslaha operates to help us decide where a basic desire can be legitimately supported by the laws don't stand on a clearly delineated plane. We will keep revisiting this matter in the remainder of the essay. 2. Juwayni's humane panopticon. On one end of Maslaha reasoning, Ibn al-Qim's, one may even have access to a married woman's body, if death is either preventable or certain, as a treatment or a last form of relief, assuming consent by both the married woman and her husband. On another end, even access to one's own wife is limited by a list of restrictions. Compare the California Code of Regulations, Section 15, adopted in essence, as we will see, by laws and regulations in Qatar and Bahrain. The restrictive Texas version limits family inmates to non-conjugal and fully supervised visits, can be found in their equivalent in the United Arab Emirates and Kuwait. Appendix 1. Let's take another jurist, this time a Shafi'i jurist of an independent mind, Abu al-Mali al-Juwayni, D. for 78/1085. In his Ghiyathi, Juwayni speaks about punishment as a matter of the politics in which Maslaha rules supreme. Juwayni, in principle, is open to factoring in all considerations in deciding the extent and intensity of punishment. He does take into account the nature of the crime and the purpose of punishment, not mere retribution, rather, some form of improvement of the criminal, among other factors. What is reasonable punishment? Juwayni looks into normal deprivation that may be associated with taking away a criminal's freedom. For a criminal to complain about short-term deprivation of basic needs, such as good food and sex, Juwayni says, is unreasonable. That is, it is reasonable for the criminal and her or his punishing authority to expect and inflict, respectively, some deprivation on the criminal, which might include malnourishment and deprivation of sex. The impact of long-term deprivation as part of the punishment, however, is a different matter. Punishments leading to excessive weakness befalling a punished criminal is unjustified. Take the law's permission of the consumption of carrion, an animal not properly slaughtered, when an alternative is not available. This permission is not limited to the cases where it is absolutely necessary for a person to eat carrion to avoid death. Juwayni then makes the most significant move. There is no difference between the human needs of a free person and an incarcerated person in that they both are human beings with human needs, and they require the satisfaction of necessities or first-order requisites in the short term, and other sustaining desirables or second-order requisites in the long term. The incarcerated are limited by humans like them from enjoying what the free normally enjoy. And the religious laws restrict the free the same way the incarcerated are restricted by their fellow society men and women. And exceptions to these restrictions and prohibitions apply just the same. Hence, a prohibition to eat carrion by free persons is mitigated, and the free person, e.g., a traveler who can't access good or proper food, halal in other words, can eat carrion when it is a first-order requisite. Should the prisoner be limited to this license throughout a long prison sentence? The answer is certainly no, given that the free person is allowed to seek more than first-order requisites, dip into second-order requisites, so to speak, when extreme circumstances become the norm, that is, when only prohibited or questionable nourishment is available in the markets. Observing the analogies between the free and the incarcerated is continued as we consider the liminal case of a person subjected to interdiction by a court, a bankrupt trader, who from now on will be prevented from using his or her own resources to buy expensive clothing, for example, or even live in an opulent house. Jurists disagree as to whether a heavily credited man may be forced to sell his own, very expensive, house and be given a more normal house in order to pay his creditors. They also disagree as to whether the heavily credited or leveraged may be forced to give up a fancy or expensive servant and only keep a modest or cheaper servant, again in order to pay what he or she owes. Juwayni here explicitly states that the interdicted still has a claim to normal clothing, even veering on the higher end, and hence does not lose access to what, for some, should be seen as his creditor's money. The logic of surveilling criminals, as in a panopticon, is not completely frowned upon in Juwayni's reasoning. A judge has the power to apply his own intuition as to whether witnesses are or are not telling the truth. He gets to separate them for interrogation and search for contradictions or conspiracy. Juwayni's license for law enforcement to supervise and control the criminal populations certainly needs to be weighed against his mistrust of imprisonment as a form of punishment and an assumption that many in prisons are brought in there unfairly. He put on a new judge to investigate unjust imprisonment among his first duties. If there is a panopticon in Juwayni's theory of criminal justice, it is quite a humane one. Legion is the evidence that Juwayni was open to allowing the political authorities to engineer the society it rules for the overall good. Most Sunni jurists agree that a punishment of 40 or 80 lashes may be assigned to those who imbibe intoxicants. We have seen that Ibn al-Qayyim sees drinking intoxicants as a much more problematic violation of Islamic laws than engaging in limited sexual pleasure outside marriage. The argument for a specific punishment of 40 or 80 lashes for drinkers as a law of the time of the revelation, Muhammad's last 23 years, is flimsy. All we have essentially is a license to inflict some limited physical punishment, throwing objects at the criminal, without any specification of a number of lashes. The specific numbers were clearly an innovation by Umar b. al-Khattab, Muhammad's second successor, to lash 40, and Umar's successor, Uthman, made it 80. Juwayni spells all this out and makes it clear that it is up to the government to punish however it sees fit. The two governments' reaction in these cases, he says, were certainly a reaction to something of a pandemic of drinking. We cannot forget the pessimistic undertone noticeable in all of Juwayni's work. Juwayni was off by about 1,000 years when he exclaimed that the end may be near and knowledge of the laws may be on the way out. Obvious, however, is Juwayni's double commitment to A. the humanity of punishment, and B. asserting the authority of the government to pursue Maslaha-based social engineering. This leads him to vacillating on governmental liability in cases of excessive punishment. Vacillate is not too strong a word. The normally decisive Juwayni comes up, in this matter, with three views. Assign full liability, given that the government would be held to have overreached. The Prophet Muhammad hasn't really assigned a severe punishment to drinkers, and it was only the view of his successors, which was a political decision, which means that all succeeding governments would need to act in this matter based on the power of discretion given to government and assume all responsibility for their overreach and should not cling to the views of the Prophet Muhammad's successors. Assign no liability, given that it is a discretionary matter and can only be understood in its context and not judged from the outside. Assign partial liability, splitting the difference between the pain normally expected in a normal punishment and whatever bodily or psychological pain caused by the additional or excessive punishment. فإن لم نوجب الضمان فلا كلام وإن أوجبه فالذي ذهب إليه أهل التحقيق أن نوجب عليه الضمان بكماله من جهة اتفاق العدول عما كان إلى جنس آخر وإذا اختلف الجنسان امتنع التقسيط ولم يتجه إلا نفي الضمان أو إيجابه وكماله. وذكر العراقيون وجها آخر أن الإمام يضمن ما بين الضرب بالنعال والضرب بالسياط فإنه يكون أشد إيلاما وأنجع وقعا فيقدر بينهما شيء بالتقريب والاجتهاد ويلزم ذلك القدر وهذا الذي ذكروه في نهاية البعد والمذهب ما ذكرناه. وقد بان حكم الضمان فيه إذا جلد الشارب 40 أو أمر حتى ضرب بالنعال وأطراف الثياب. A balance of responsibilities. Surveillance applied to both A. the suspicious in society and B. state authorities implementing the laws who may have betrayed the terms of their service brings a balance of responsibilities, mirroring a balance of power in a Muslim society. Both those who failed to follow the laws and those who may have failed to implement the laws are subject to review and their actions are subjected to neutralization and correction. Our Juwayni offers some of the rarest expressions of the review of court and administrative decisions in criminal matters. Knowing that abuse of power is so intrinsic to human beings, and being acutely aware that judicial and administrative discretion is both essential and a dangerous tool in the art of government. Judges may imprison to extract compensation, apply threat, or punish for bad behavior. وحبس القضاة منقسم إلى حق وظلم وأدب وحمل على تأدية حق فيحصل مما بسطناه أن ما سار إليه الجماهير التشبث به إلى التفحص من غير أن يرد إلى الحبس. Hence, these decisions may be reviewed once the power of a given administrator or judge wanes, since we then have an opportunity to correct injustice established under their authority. Juwayni is open to retrying cases when the need is obvious. Most importantly, Juwayni reiterates his openness to surveillance as a standard for soft control of the society, especially when imprisonment is not clearly justifiable. He applies this to threshold cases, where it is unclear whether a given subject is or is not a culprit in a crime. In these cases, the suspect may be surveilled, neither imprisoned, nor left alone as a free individual. Appendix 3, Nihayat al-Matlab, 15:574-5. Abu al-Mali al-Juwayni is hardly alone in his posture, traversing a rational political science and a meaningfully humane legal and moral science. His sources in the section discussed above include 3 centuries of jurists, from M. B. Idris Shafi'i d. 204/820, and 3rd and 4th century commentators on his work all the way to al-Qadi al-Baqillani d. 403/1013. And this debate and the juristic posture displayed in it is not limited to Shafi'is. In a missing text, preserved in part from later quotations, Ibn Hazm, d. 456/1064, offers a commentary on proper policies and administrative principles regarding criminals and those suspected of criminality in society, as well as the incarcerated. The police, he says, are not meant to be there to chase people who may or may not be criminals. This would be an unnecessary disturbance of social peace. Criminals will announce themselves, he says. When caught, they may be punished. Then prisons should never be a salad of criminals of all grades, lest those of a vulnerable character be hardened into the recalcitrant, unreformable type. After ensuring that men have their prisons and women theirs, each class must be further divided into subclasses based on the danger they pose and the nature of their previous record. The vacillation between firmness in assigning proper penalties and the hope of reform is best attested in a mandatory policy. Ibn Hazm suggests that a religious leader be assigned to all classes of prisoners and be sufficiently compensated by the government from the treasury. A heavily guarded and isolated thaqif prison ought to be dedicated to the body and those feared to spread their terror or criminality. Another prison may be dedicated to the corrigible and those incarcerated for financial liabilities or for having an untrustworthy character. All must be reviewed and examined after incarcerated. A prison for females needs to be separate. It would be a good policy to also divide these into those convicted of awful crimes and those who are not. In all cases, a religious leader must be assigned and paid from the treasury to lead them in their rituals. 3. Laws as medicine. For al-Din b. Abd al-Salam, henceforth is, law and medicine are unified by a simple principle: do no harm. In his Qawaid al-Ahkam, fi Maslaha al-Anam, he delineates the task of a jurist as balancing needs and expectations, much of which are unachievable, even if they appear so, without some sacrifice. In one stroke, Is lowers the expectations of the practitioners of either art, law, or medicine, by letting them know that all good things cannot be achieved at once or all the time. He then establishes the principle that the practice of law and medicine involve an art of choice, and it is only the wise jurist and wise doctor who knows how to evaluate and determine which course of action is to be preferred. And by way of illustration mocks vegetarians who pretend that humans could survive without consuming the flesh of animals, making the case that preferring the lower animal to the higher is the science of the foolhardy. IAS's tone is stoutly realistic. Our worldly life is an existence of unclarity and doubt. It is embedded, however, with an opportunity for discernment and understanding of the proper way to see things. But the bottom line is that what benefits us in this world must be derived from that little fallible tool, human reason. What else? The Maslaha of this world are exclusively comprehensible and accessible in the language of Zan, i.e., conjecture or educated guesses. The hereafter, and what makes it a life of reward, by contrast, is only learnable via divine revelation. IS also very simply and quickly resolves a puzzle that left Muslim jurists helpless for a long time. Were there laws before the laws? What can we say about norms before the revelation? Some said all was allowed. Some said all were prohibited. Some resorted to declaring their ignorance of the matter and suspended judgment. IS says it is simple. The Maslaha of this world were always the business of the perishable human mind. Those pertaining to an everlasting life need to be learned from the divine message. Where's the problem? IS then moves to what might seem to be another jagged inquiry. Could good lead to bad and bad to good? Could benefit arise from cost and cost from benefit? Could bona fide desirables be either source or effect of undesirables? Or, said another way, could maslaha and its opposite, mafsada, be in each other's way, and if yes, what is the way? Here is IAS's answer. The laws might prohibit what appears to be masali, because they are nothing but a path to its opposite. Think of pleasures one only attains by the means of harmful substances or risks to one's body or psyche. The laws are also known to recommend tolerating and ensuring undesirables or mafasid to fulfill a higher good. Think of punishments applied to criminals. Punishment is always an undesirable, which we unhappily inflict on some for the sake of the higher good or desirable. Objective of peace and order in society. The analogy with medicine jumps at us again. Doctors would, nay should, cut a patient's hand if its defect is bound, if left alone, to spread in the body and end its life. The permanence of change. In the same vein, subsequent jurists who inherited and considered a longer legal history found the law of change to result in an implicit legal idea worthy of the sobriquet, the permanence of change rule. In his Nashr al-Arf, treatise on social custom and laws, Ibn Abidin, d. 1252/1836, provided a long list of modifications in Hanafi legal doctrines based on changes in the social conditions in the society governed by the laws. This is a hodgepodge of legal doctrines and cases, where some of the change in the laws is properly understood as a change in how words are used, and some based on changes in the conditions of the market, and most are, in fact, properly understood as changes in the properly protected maslaha of the individual or the group. Laws are, Ibn Abidin asserts, partly embedded with attention to the social standards under which they are devised, and when these conditions change, not changing the laws is, in reality, an improper change of them. The laws, in a word, need to change to remain the same. 4. Masali trounce texts. Najm al-Din al-Tufi, d. 716/1316, was accused of shurism, zandaka, i.e., licentious deviation from Islam with the employment of obscurantist language and mysticism all at once. Placeholder. 5. Masali and rights. The Arabic word hak remains vague and susceptible to eclectic borrowing from modern and pre-modern notions of rights. Words such as jus, the Latin for both right and law or legal, and droit, French for both right and law. Hence faculty droit is school of law or school of the study of rights. How long journey and didn't, until very, very recently, indicate independent claims before a case is decided. In Natural Rights Theories, 1979, Richard Tuck showed that the long career of the word just made it mean, on different occasions, the correct balance in the legal or moral world, what accounts for all considerations and imperatives of law and order, or in some contexts, a simple claim to property, my jus or I use, house or land, equals belongs to me, among other meanings over time. Despite a shorter history, droit as right is just as rich. Hak needs its own investigation, and it has to be a long one. It is possible that Muhammad B. Idris al-Shafi'i d. 204/820 was the first to coin the word in the sense in which humans have rights and God has rights, where these may be in competition and where one is stronger, and that all Shafi'i was addressing was a narrow matter within criminal law in Islam. Hence, hudud and jinayat punishments are there to protect rights, and if I can forgive my father's killer, my human right takes priority over that of God. While in a fornication claim, I couldn't forgive, nor can anyone, because God's right takes priority. There's no safe side to err on, however. While proposing 5 sources for rights according to the Islamic legal tradition, Abd al-Razak al-Sanhuri lamented the misery of modern Muslim jurists rushing in the path of modernizing Islamic law via taking modern language and Islamicizing it, Appendix 5. It is not that Sanhuri didn't want scholars of Islamic law to study other legal systems. The mistake Sanhuri was talking about is the lack of independence of the jurist's mind that considers different legal views while speaking in the name of one of them. Anchoring Masali. Whether rights are or are not independent of a calculation within a legal case that would help us determine their extent is one question. Another is what they are made of. One may, Sanhuri says, classify rights into 1. Those anchored in a personal legal relationship, that is, rights of person via vis person, and 2. Those anchored in personal powers over an object, rights of person over an object. I could state the right, or interest, or legal advantage I have over my debtors as a personal link between me and a debtor that allows me to collect my debt. Number 1. And I could assert the relationship between me as an owner of my house and all human beings as an advantage I have against them all due to my ownership of my house. Number 2. This distinction is unknown in Islamic jurisprudence, Sanhuri asserts, and its absence appears to be an advantage. Sanhuri's introduction to his commentary, Al-Wazit, on Egypt's civil code tells us that European jurists have attempted to reduce each one of these two classes to the other, resulting in a classification of legal systems into those that are person-bound and those that are bound to the material world of objects. For many reasons, Sanhuri dedicated most of his study of the sources of legally valid claims, Masdar al-Haq, whether we call these claims Maslaha or rights, to claims whose cause is ultimately human behavior. The book may even pass for a study of contract theory, covering as it does all the quirks affecting the commitments imposed by successful and unsuccessful expressions of the human will. This takes you from the promise stage of a commitment through its complete and incomplete or aborted expressions of a commitment, passing by all the defects that may befall this commitment and what ensues in each case. Included are natural emergencies or forces of nature that serve as impediments to the conclusion and enforcement of legal commitments as a subsidiary to legal claims. In public law, the power of government is supposed to be more secure in creating commitments that are independent of the will of the populations under this government. Without going as far as those who claim that even public laws, criminal laws most notably, are nothing but contracts in disguise, we can also learn from calm perusal of the different laws within different legal systems, pre-modern or modern, in the areas we like to call civil and criminal and personal status laws, if this third category is isolated as such, that laws are meant to make sense to their populations. That is, they need to make sense of and for the population's everyday life, as opposed to being justified by a rational, or often not so rational, calculation by every individual of their own interest at the time of a political election. More on democracy below. Laws need to make sense as moral claims, independent of the power of government. Both authors of the current essay are in agreement that an advantage in Islamic moral and legal reasoning is that it looks at interests holistically, as opposed to classifying them into claims against one or against all. This advantage ought to, we argue, be carried further. Order and peace in a stable society is achieved when all are treated with attention, within a balance that takes all considerations into account. In the markets, people are free to exchange, and price setting or allowing monopolies, for example, are frowned upon in Islamic legal reasoning. A good government administers a life of diverse human beings who may not believe the same thing or want the same thing. The most successful governments in Islamic history, and the ones that lasted longest, were ethnically diverse and enjoyed what Sherman Jackson calls legal pluralism. Different madhabs operated simultaneously, and all madhabs agreed in principle that claims and appeals for legal protection, for the benefit of some being the same for the benefit of all, are heard when they seem reasonable. Rights, to make the point again, are nothing but successful claims, vindicated by the law, to a legal privilege or position. That is, they are acknowledged positions based on a valid maslaha. Before the validation, a maslaha may be in need of defending itself against another. After it is acknowledged as legally effective, it is part of the legitimate maslaha and part of the accepted legal order. The practical question we kept revisiting as we considered the different sides of how maslaha may be conceptualized and comprehended has been the question of calculating the interests of society and the interests of prisoners and their overlap. That is, when a society calculates that its prisoners' interests are part of its own long-term interest, when it refrains from turning these prisoners into even worse misanthropes inside its prisons, since they are meant to get out at some point. We may not be in total agreement about how to address this matter. One of us is convinced that the idea of imprisonment as punishment has never worked for any society. The logic of compensation, embedded in the laws of delicts in ancient Roman law, torts in modern American law, and damanat in medieval and early modern Islamic law, is the only meaningful logic to address violations of the laws, civil or criminal. This view even goes further. It holds reasonable the idea of punishing the society itself, not only its misanthropes. For the society's abandonment of those members in it whose violation of the law ascends to criminal behavior, including murder and treason, the most extreme forms of antisocial behavior. One can take a page from Joanne's manual, discussed earlier, to apply surveillance for known violators of the laws to reduce the chances that they would strike and cause damage. If the society has an argument that some of its members are simply sick, incorrigible, it might decide to eliminate these sick members, pretending to have established correctional institutions for these sick members with a prayer that torturing them for years might make them come back and follow the laws just doesn't make much sense. A government that has the trust of its population, it is true, has more leeway in forgiving its criminals, as long as this doesn't become a habit or a path to favoritism. For example, if a government, in a Muslim world or somewhere else, allows the head of the executive to place his own private lawyer at the top of the judiciary, the way President Johnson made Abe Fortas a Supreme Court justice, then this government's authority ought to be questioned. The Prophet Muhammad is known to have forgiven someone who, to all appearances, was a random person entangled in an event that involved attempted rape, or perhaps a completed rape, with a group of men who tried to save a lady, crying for help. The lady herself, the story goes, wasn't sure at some point who was the man who attempted to rape her. Or, she may have simply lied. In either case, a man other than the one she accused of overpowering her confessed. The Prophet is said to have issued a pardon for the man who confessed, possibly given all the confusion and doubt in the event. The report has been questioned, but it seems to have produced acceptance, on rational grounds, for the conclusion that the government must be given some limited authority to issue pardons to criminals. The abuse of pardon power being what it is in our time, we will leave this as a matter that requires further reflection, which we need to defer for another opportunity. Law's intelligibility and the trap of democracy. If we're not aiming at describing some sort of paradox, we have to allow our minds to self-consciously describe our reasoning within a certain legal tradition. If we are committed to a certain legal tradition or our free reasoning, which we allow to draw on multiple traditions, we may decide to also judge the similarities and dissimilarities between our way of reasoning and other ways, whether they are of mixed origin or specific to a given legal tradition. We are studying Maslaha, and we think that it is an authentic term of the Islamic legal tradition. And we think that rights, as absolute claims before a case is considered, probably never existed in the mind of a medieval scholar of Islamic legal reasoning. If we want to invent them, we need to think of the consequences. If we, say, propose that a prisoner has a basic right to reasonable nourishment and at least some infrequent sexual pleasure, possibly guided by Ibn al-Qayyim and Juwayni, we need to reflect on the nature and cost of these absolute rights. Absolute rights don't compete. Otherwise, these are simply Maslaha, or claims of what works out for this or that person, natural or legal, such as the society or even a private company that supplies fancy prison complexes. Utilitarianism, for all its faults, acknowledges that it does the best it can and no more. A theory of rights, when not reduced to utilitarianism, falls foul of the danger of asserting a claim it couldn't fulfill. We are certainly suspicious of blind borrowing or being impressed by Euro-American, aka Western, ways of legal reasoning. We are not opposed to studying them. In fact, it is studying them from time to time that killed in us much of the common respect for them. This was not the way of the pioneers of modern, Arabic legal studies in the Egyptian monarchy of the 20th century, whether Ahmad Amin, Bey, of the Cairo Law School, or Ahmad Ibrahim of Dar al-Ulum, the one Sanhuri singles out for criticism as indicated at the opening of this section. These jurists were convinced of the superiority of modern legal reasoning over that of the medieval world, whatever its source. We also think that one cost of democracy, that modern magical tool that separates civilized from uncivilized society and denotes equality, justice, and all these good and fun things, is that it runs out of meaningful explanations of its commitments. If the people are truly independent and free to do whatever they agree to do, they may decide to give up their power to their emperor. This is not exactly a pink elephant thought. It is a concept based in a well-known legal tale. Whether fictional or real, a lex regia or a royal statute was issued by the Roman people transferring the power of government to the emperor. Thus the digest of Justinian quotes, in 1.4.1, Ulpian, what pleases the emperor has the force of law. The emperor, not God, or Stoic's cosmic reason, to which a jurist may appeal. Something like this is happening in the United States, as we write in the summer of 2025, since the U.S. population prefers living a life of indifference to the self-exerting life of reason. This leads to an abandonment of thinking and explaining the laws. The people made a choice, that is, by electing someone for whom they don't care or by staying at home. The people, in other words, gave up on debating, explaining, or even rationalizing. The Maslaha that deserves studying, and the rights that deserve to be taken seriously for us, must be ones that can be debated, rather than relegated to a majority, silent or talkative, let alone a powerful minority capable of scaring and silencing others, while attending to the formalities of democratic rule. After Sanhuri, even 76 years after his civil code, 1949, and 54 years after his commentary on it, Sanhuri sounds more like a contemporary than a historical figure. Or it may be that we embrace, instead of wanting to alter or revise, his commitment to the thought that it is enough for a scholar of Islamic moral and legal reasoning in our time to analyze the juristic arguments of the Islamic traditions, deriving a view for oneself from it, while also weighing arguments from other traditions, as these allow one to clarify his position and the arguments for it. Basic non-negotiable rights don't exist, we are convinced. But qualified rights, strong versions of Maslaha, are defensible as foundations to modern legal reasoning. Shifting the debate from the Anglophone language of utilitarianism and natural or human rights to Arabic, it turns out, is responsible for this solution. As we make the move back to the English language and its world, we find the most direct expression for this view to propose different translations for the words we can use in Arabic, depending on the sentence. In this sense, this essay confirms conclusions already made in previous studies. We are aware that Maslaha is overstudied. This essay never promised a literature review of modern works on Maslaha. Academics, not only monks, need to develop a degree of ascesis. We decline to indulge in employing what we know to win imagined debates against those on an opposite end. We, hence, refrain from debating historicists of different types. We have no interest in discussions of the exact differences between Islamic jurisprudence and other forms of political and legal reasoning in the world of today. We doubt, though, that an argument can be made based on the sources we covered that a realist heir of the Islamic legal and moral traditions would consider it a waste of their energy to weigh moral considerations as they address a question of moral and legal reasoning from their standpoint. As we live in a post-moral world, the argument would be that Muslim jurists, like other jurists or political theorists, should and would save their energy, instead, to the more useful calculations of one's chances of personal success, warts and all. That is, with cruelty and indifference to the suffering of others being included in the package. We don't see that. Islamic jurisprudence allows its students to see moral and practical considerations discussed and weighed differently from any other system of morals and politics today. And the theoretical model is borne out to an extent by the practice. Many Muslims, based on purported moral and political imperatives, avoid what they consider unlawful gains and unlawful domestic arrangements and avert excessive entrenchment in and unworthy uses of power. Whether Muslim communities are inevitably led, over time, to pursuing some effectual truth about the world that ignores moral elements in the traditional sense, to follow Harvey Mansfield's interpretation of a Machiavellian idea, might be an interesting question in its own right. A question for the future. Appendix 1. California Code of Regulations, Title 15, Section 3177, Family Visits. Universal Citation, 15 CA Code of Regs 3177. Current through Register 2025 Notice Reg Number 13, March 28, 2025. Institution heads shall maintain family visiting policies and procedures. Family visits are extended overnight visits, provided for eligible incarcerated persons and their immediate family members as defined in Section 3000, commensurate with institution security, space availability, and pursuant to these regulations. Each institution shall provide all necessary accommodations, except for food, at no cost to the incarcerated persons and their visitors. Institutions shall require eligible incarcerated persons to purchase all food for the family visit through the institution family visiting coordinator. Each institution family visiting menu shall provide a balanced variety of nutritional selections. At all CDCR conservation camps, the visitors shall be required to bring all food for the visit. Only those immediate family members as defined in Section 3000, including registered domestic partners, are authorized for family visits. A. When a bona fide and verified foster relationship exists between an incarcerated person and another person, by virtue of being raised in the same foster family, the person may be approved for family visiting with the prior approval of the institution head or designee. B. Family visiting is a privilege. Eligibility for family visiting shall be limited by the assignment of the incarcerated person to a qualifying work/training incentive group as outlined in Section 3044. 1. Family visits shall not be permitted for incarcerated persons convicted of a violent offense where the victim is a minor or family member or any sex offense, which includes but is not limited to the following penal code sections. 187. When the victim is a family member as defined in Section 3000 or minor. 192. When the victim is a family member or minor. 243.4. 261. 261.4. Incarcerated persons may be prohibited from family visiting where substantial documented evidence or information of the misconduct described in Section 3177, B.1, exists without a criminal conviction. The evidence or information appropriate for the purpose of this regulation shall include rule violation reports as well as the standard described in Section 3173.1. B. Incarcerated persons convicted as a minor of a violent offense where the victim was a minor or family member, excluding any sex offense, shall have eligibility for family visiting determined by classification committee provided the incarcerated person has demonstrated sustained positive behavior to include no serious rules violation reports in the last 5 years and documented participation in self-help groups, e.g., Anger Management, Narcotics Anonymous, Alcoholics Anonymous. The classification committee shall consider the circumstances of the offense involving a minor or family victim in determining whether the incarcerated person poses a threat of harm to visitors during a family visit. In making its determination, the classification committee shall consider, but is not limited to, arrest reports, probation officer reports, court transcripts, parole revocation transcripts. C. Incarcerated persons convicted of a violent offense where the victim was a minor or a family member, excluding any sex offense, may be eligible for family visiting as determined by classification committee, providing the incarcerated person has demonstrated sustained positive behavior to include no serious rules violation reports in the last 10 years and documented participation in self-help groups, e.g., Anger Management, Narcotics Anonymous, Alcoholics Anonymous. The classification committee shall consider the circumstances of the offense involving a minor or family victim in determining whether the incarcerated person poses a threat of harm to visitors during a family visit. In making its determination, the classification committee shall consider, but is not limited to, arrest reports, probation officer reports, court transcripts, parole revocation transcripts. D. Family visiting shall be restricted as necessary to maintain order, the safety of persons, the security of the institution/facility, and required prison activities and operations, pursuant to Section 3170. 2. Family visits shall not be permitted for incarcerated persons who are in any of the following categories. A. Designated close custody. B. Designated a condemned incarcerated person. C. Assigned to a reception center. D. Assigned to a restricted housing unit. E. Designated C status. F. Guilty of one or more Division A or Division B offenses within the last 12 months. Or G. Guilty of distribution of a controlled substance while incarcerated in a state prison under subsection 3016E. Loss of family visiting overnight in accordance with subsection 3315 G5H. 3. Family visits shall be permitted only in CDCR institutions and conservation camps. C. Unescorted minors of the incarcerated person's immediate family shall not participate in family visits. Exceptions include an incarcerated person's legal spouse, the incarcerated person's children or legal stepchildren, and the incarcerated person's own brothers or sisters when the institution head or designee approves such unchaperoned visits. D. Incarcerated persons shall not be eligible for a family visit while any action that restricts, suspends, or denies their contact with a visitor or visitors during regular visiting is in effect. Family visits may be revoked or suspended without such action affecting an incarcerated person's eligibility for contact or non-contact visits. E. Each incarcerated person shall be subject to disciplinary action, which may include suspension or exclusion from participation in the family visiting program, for any willful damage of a unit and/or furnishings or for failure to maintain the cleanliness of the family visiting program unit. F. Visitors failing to report to the visitor processing area by 11 a.m. without the notification and approval of the family visiting coordinator are subject to cancellation of the visit and suspension of family visiting program privileges for 6 months. G. Incarcerated persons with a disability requiring an accommodation for family visits shall give 72 hours notice of any request for accommodation. For the much more restrictive regulations of correctional facilities in the state of Texas, where one may be visited by family members for 30 hours, but only for normal interaction and under full surveillance, see General Information Guide for Families of Inmates. https://www.tdcj.texas.gov/documents/general_information_guide_for_families_of_inmates_english.pdf. Note the tone of the instructions for family visitors. Hats may be worn, but will be searched. Some of the instructions are reasonable upon reflection, but have a clear tone of imposing limitations. Ibn al-Qayyim, al-Turik al-Hakmiyya, 1:135-8. ومن ذلك أن عمر بن الخطاب رضي الله عنه أتي بامرأة زنت فسألها فأقرت فأمر برجمها. فقال علي رضي الله عنه شرطة لعل لها عذرا، ثم قال لها: ما حملك على الزنا؟ قالت: كان لي خليط وفي إبلهم ماء ولبن، ولم يكن في إبلي ماء ولا لبن، فظمئت فاستسقيته فأبى أن يسقيني حتى أعطيه نفسي، فأبيت عليه 3. وفي سنن البيهقي عن أبي عبد الرحمن السلمي أتي عمر بامرأة جهدها العطش فمرت على راع فاستسقت فأبى أن يسقيها إلا أن تمكنه من نفسها ففعلت، فشاور الناس فيرجمها. فقال علي: هذه مضطرة، أرى أن تخلي سبيلها، ففعل. قلت: والعمل على هذا لو اضطرت المرأة إلى طعام أو شراب عند رجل فمنعها إلا بنفسها وخافت الهلاك فمكنته من نفسها فلا حد عليها. فإن قيل: فهل يجوز لها في هذه الحال أن تمكن من نفسها أم يجب عليها أن تصبر ولو ماتت؟ قيل: هذه حكمها حكم المكرهة على الزنا التي يقال لها إن مكنت من نفسك وإلا قتلك، والمكرهة لا حد عليها ولها أن تفتدي من القتل بذلك، ولو صبرت لكان أفضل لها، ولا يجب عليها أن تمكن من نفسها، كما لا يجب على المكره على الكفر أن يتلفظ به، وإن صبر حتى قتل لم يكن آثما، فالمكرهة على الفاحشة أولى. فإن قيل: لو وقع مثل ذلك لرجل وقيل له: إن لم تمكن من نفسك وإلا قتلناك، أو منع الطعام والشراب حتى يمكن من نفسه وخاف الهلاك، فهل يجوز له التمكين؟ قيل: لا يجوز له ذلك ويصبر للموت. والفرق بينه وبين المرأة أن العار والفساد الذي يلحق المفعول به لا يمكن تلافيه، وهو شر مما يحصل له بالقتل أو منع الطعام والشراب حتى يموت، فإن هذا فساد في نفسه وعقله وقلبه ودينه وعرضه، ونطفة اللوتي مسمومة تسري في الروح والقلب، فتفسدها فسادا قل أن يرجى معه صلاح، ففساد التفريق بين روحه وبدنه بالقتل دون هذه المفسدة، ولهذا يجوز له أو يجب عليه أن يقتل من يراوده عن نفسه إن أمكنه ذلك من غير خوف مفسده. ولو فعله السيد بعبده بيع عليه ولم يمكن من استدامة ملكه عليه. وقال بعض السلف: يعتق عليه، وهو قول قوي مبني على العتق بالمثلة، لا سيما إذا استكراه على ذلك، فإن هذا جار مجرى المثلة. ميكتل بي سليمان النبهان التمر ستوري. نزل في نبهان تمار، وذلك أنه كان له حانوت يبيع فيه التمر، فأتته امرأة تريد تمرا، فقالت لها: ادخلي الحانوت فإن فيه تمرا جيدا. فلما دخلت راودها عن نفسها فأبت عليه، فلما رأت الشر خرج فوثب إليها فضرب عجزها بيده، فقالت: والله ما نلت مني حاجتك ولا حفظت غيبة أخيك المسلم. فذهبت المرأة وندم الرجل، فأتى النبي شرطا صلى الله عليه وسلم الشرطة فأخبره بصنيعه. فقال له النبي شرطا صلى الله عليه وسلم الشرطة: ويحك يا نبهان، فلعل زوجها غاز في سبيل الله. فقال: الله ورسوله أعلم. فقال: أما علمت أن الله يغار للغازي ما لا يغار للمقيم؟ فلقي أبا بكر شرطا رضي الله عنه شرطا فأعلمه، فقال: ويحك فلعل زوجها غاز في سبيل الله. فقال: الله أعلم. ثم رجع فلقي عمر بن الخطاب شرطا رضي الله عنه شرطة فأخبره، فقال: ويحك لعل زوجها غاز في سبيل الله. قال: الله أعلم. فصرعه عمر فوثئه، ثم انطلق به إلى النبي شرطا صلى الله عليه وسلم شرطة، فقال: يا رسول الله، إخواننا غزاة في سبيل الله تكسر الرماح في صدورهم، يخلف هذا ونحوه أهليهم بسوء، فاضرب عنقه. Egyptian Administrative Court on Inmates' Rights to Procreate via Artificial Insemination 2025. هيئة مفوضي الدولة توصي بأحقية زوجة سجين في إجراء حقن مجهري. أصدرت هيئة مفوضي الدولة بمحكمة القضاء الإداري توصية تاريخية بأحقية زوجة سجين في الحصول على عينات وتحاليل من زوجها المحكوم عليه بالسجن المشدد لمدة 15 عاما، والمودع بمركز الإصلاح والتأهيل بالمنيا لإتمام عملية الحقن المجهري على نفقتها الخاصة. وجاءت التوصية في تقرير الهيئة بشأن الدعوى رقم 41283 لسنة 79 كارف، والصادر في أبريل 2025، حيث استندت الهيئة إلى مواد الدستور المصري التي تنص على أن الأسرة هي أساس المجتمع، وأن الدولة ملتزمة بالحفاظ على تماسكها واستقرارها، مؤكدا أن حرمان الزوجين من الحق في الإنجاب يمثل انتهاكا صارخا لحقوق الإنسان. وأوضحت الهيئة أن الحرية الشخصية والحق في تكوين أسرة من الحقوق الدستورية الأصيلة التي لا يجب أن تسلب حتى في حال تقييد الحرية بسبب العقوبة الجنائية. كما استند التقرير إلى أحكام سابقة صادرة عن المحكمة الإدارية العليا والمحكمة الدستورية العليا في هذا السياق. ولتعزيز رأيها، استعانت الهيئة بعدد من السوابق القضائية الدولية، من بينها قضية ديكسون ضد المملكة المتحدة التي نظرتها المحكمة الأوروبية لحقوق الإنسان، والتي أقرت بحق السجناء في الحصول على خدمات التلقيح الصناعي، واعتبرت أن رفض هذه الخدمات يعد انتهاكا للمادة 8 من الاتفاقية الأوروبية لحقوق الإنسان. كما استشهدت الهيئة بالقواعد النموذجية الدنيا لمعاملة السجناء المعروفة بقواعد نيلسون مانديلا التي أقرتها الأمم المتحدة، والتي تنص على ضرورة توفير الرعاية الصحية للسجناء على قدم المساواة مع باقي أفراد المجتمع. وفي دعم إضافي، استند التقرير إلى الاتفاقية الدولية للحقوق المدنية والسياسية المصادق عليها بموجب قرار رئيس الجمهورية رقم 536 لسنة 1981 التي تؤكد على الحق في الحياة والحرية والسلامة الشخصية، وكذلك على الحق في تكوين أسرة. وأشارت الهيئة كذلك إلى أحكام القانون رقم 396 لسنة 1956 بشأن تنظيم مراكز الإصلاح والتأهيل وتعديلاته الأخيرة التي تضمن للسجناء الحق في الرعاية الصحية والفحوص الطبية، وهو ما يعزز قانونية وإمكانية إجراء مثل هذا النوع من العمليات. وأكدت الهيئة في ختام تقريرها أن السماح لزوجة السجين بالحصول على العينة اللازمة لإجراء الحقن المجهري يتسق مع روح الدستور المصري وأحكامه ومع مبادئ العدالة والكرامة الإنسانية. الشروق، الأحد 18 مايو من 2025 إلى 5:53 مساء. آخر تحديث، الأحد 18 مايو من 2025 إلى 6:30 مساء. Textualist Bents, Cost and Benefit. فتح الباري لابن حجر شرطة السلفية 10/409 داش 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 فصل. انتهى. فتح الباري شرطة 10/411. فتح الباري لابن حجر 11/503. فتح الباري لابن حجر شرح حديث رجل أصاب من امرأة كبلة. ألي هذا؟ فتح الباري لابن حجر طبعة السلفية 2/9 كتاب مواقيت صلاة شرطة باب فضل الصلاة لوقتها. شرح النووي على مسلم 1/7/7/8/9 شرطة باب قوله تعالى إن الحسنات يذهبن السيئات. معنى اللمم عند الإمام النووي. يتفق النووي مع ابن القيم المغفرة ومعن. شرح مسلم 9/1/0/9 شرطة كتاب الحج والنأي هو البعد. Appendix 2 الجويني في الغياثي صاد 4/7/6 داش النظام. Down right arrow, down left arrow. Abu al-Mali al-Juwaini, D. For 78/1085, edition Adib, Gayat al-Yamam, Fi Iltiath al-Zulum, Maktabat Imam al-Haramain, 1980, pages 521-2, art. 837. Down right arrow, down left arrow. Abu al-Mali al-Juwaini, D. For 78/1085, edition Adib, Nihayat al-Matlab, Fi Durayat al-Madhab, Dar al-Manhaj, 2007, 17:332-5, art. 11,206-9. روي أنه صلى الله عليه وسلم أتي بسكران فقال اضربوه فضربوه بالأيدي والنعال وأطراف الثياب وحثوا عليه تراب ثم قال بكتوه أي عيروه وبخوه شرطا ثم قال أرسلوه فلما كان في زمن أبي بكر أتي بسكران فأحضر الذين شاهدوا ذلك فقوموه ب40 جلدة أي عدلوه بها وكان يجلد في أيام خلافته 40 وكذلك عمر في صدر خلافته. ثم تتايع الناس في شرب الخمر فجمع الناس واستشارهم فقال إن الناس تتيعوا في شرب الخمر واستقلوا هذا القدر من الحاد فماذا ترون؟ وكان علي رضي الله عنه فيهم فقال أرى أن يوجد 80 فإن من شرب سكر ومن سكر هذا ومن هذا افترى فأرى أن يبلغ حد المفترين. وكان يجلد عمر في بقية زمانه 80 وجلد عثمان في خلافته 80. فلما آل الأمر إلى علي عاد إلى 40 وقال ليس أحد أقيم عليه حدا فيموت فأجد في نفسه منه شيئا من أن 1 الحق قتله إلا شارب الخمر فإنه شيء رأيناه بعد رسول الله صلى الله عليه وسلم فمن مات منه 2 فالدية على عاقلة الأمام. أو قال في بيت المال فشك من الشافعي 3 وروي أن رسول الله صلى الله عليه وسلم أمر حتى جلد شارب 40 وروي أن رسول الله صلى الله عليه وسلم قال من شرب الخمر فجلدوه فإن عاد فجلدوه فإن عاد فاقتلوه 4 والقتل منسوخ بالإجماع في ذلك. وإنما نقل القول البعيد عن الشافعي في القتل في الكرة الخامسة في السرقة 11,207. فإذا ثبتت هذه الأخبار وقد استقسينا طرقها في الخلاف فنقول أجمع الأصحاب على أن الشارب يجلد بسيات. ثم قال الأئمة لو رأى الإمام الضرب الشارب بالنعال وأطراف الثياب كما نقل عن مجلس رسول الله صلى الله عليه وسلم جاز ذلك فإن النبي صلى الله عليه وسلم أمر بذلك ولم يثبت فيه نسخ ولم يعد الصديق عنه إلا على تعديل 1 وتقريب الصدر عن اجتهاد. والسبب الذي سوغ ذلك للصديق أنه لم يرل ما أمر به الرسول صلى الله عليه وسلم ضبطا يسير إلى تحديد وعلم أن ما كان كذلك فللاجتهاد فيه مساغ. فإذا جاز العدول إلى السيات فلا إن يجوز الضرب. 2. بالنعال وأطراف الثياب أولى. ثم الضرب معدلا بمقدار أمكن من تقدير ضربات ملتبسة ب40. فإذا ساغ للصديق ما فعل فلا منع من الرجوع إلى الأصل، هذا هو المذهب. وذكر عراقيون هذا ووجها آخر أنه لا يجوز لنا الضرب بالنعال وأطراف الثياب فإن كفينا مؤنة التعديل وقد بعد العهد وتناسخت العصور، ونحن لو ضربنا بالنعال بين أن نحط عن القدر المستحق وبين أن نزيد، وهذا وإن أمكن توجيهه فالمذهب غيره وقد نقله العراقيون وزيفوه. ولو رأى الإمام يجلد الشارب 80 تأسويا بما استقر عليه رأي أمير المؤمنين عمر، فالذي ذكره الشيخي ومعظم الأئمة أن ذلك سائغ على ما سنوضحه بالتفريع إن شاء الله تعالى. وقال القاضي: الصحيح من مذهبنا أنه لا مزيد على ما رآه الصديق في زمانه من أنه عدله شهادة الذين شاهدوا ما جرى في مجلس الرسول صلى الله عليه وسلم، وكان مستند حكمه ما ذكرناه. والذي رآه عمر رأي له، ونحن لا نلتزم أن نتبع أحد الصحابة رضي الله عنهم إلا ما نراه معتقدا بأوجه المسالك. ثم قال: وذهب بعض أصحابنا إلى أنه يجوز تبليغ الحد 80، فانتظم وجهان إذن في هذا الطرف. ولا خلاف أنه لا يجوز أن يتلقى من تردد الصحابة رضي الله عنهم في ذلك جواز المزيد على 80. 11208. فإذا تبين ما يعاقب به الشارب فنحن نذكر ما يتعلق بعقوبة الشارب لو أفضت إلى الهلاك. قال الأصحاب: لو وقع الضرب بالنعال وأطراف الثياب وأفضى إلى الهلاك فلا ضمان. هكذا قاله الأصحاب، ولا شك أن من منع ذلك على الوجه الغريب الذي حكاه العراقيون فإنه يثبت الضمان. ثم نفى الأئمة الضمان وهو مشروط بوقوع الضربات على حد يعادل ب40 جلدة من غير مزيد. ثم قال الأئمة: إن جلد الإمام الشارب 40 تأسويا بالصديق فأفضى إلى الهلاك ففي وجوب الضمان قولان، أحدهما يجب لما روينا عن علي رضي الله عنه أنه قال: إلا الشارب فإنه شيء رأيناه بعد رسول الله صلى الله عليه وسلم، وفيه معنى وهو أنه معدول عن المنقول عن زمن رسول الله صلى الله عليه وسلم، وهذا إنما يستقيم لو لم يصح أن الرسول صلى الله عليه وسلم جلد الشارب 40 وقد روى الإثبات ذلك. فعلى هذا إن صح الخبر يجب نفي الضمان كما يجب ذلك في حد الزنا وحد القذف. فإن لم نوجب الضمان فلا كلام، وإن أوجبناه فالذي ذهب إليه أهل التحقيق أن نوجب عليه الضمان بكماله من جهة اتفاق العدول عما كان إلى جنس آخر، وإذا اختلف الجنسان امتنع التقسيط ولم يتجه إلى نفي الضمان أو إيجابه وكماله. وذكر العراقيون وجها آخر أن الإمام يضمن ما بين الضرب بالنعال والضرب بالسيات فإنه يكون أشد إيلاما وأنجع وقعا، فيقدر بينهما شيء بالتقريب والاجتهاد ويلزم ذلك القدر، وهذا الذي ذكروه في نهاية البعد، والمذهب ما ذكرناه. وقد بان حكم الضمان فيه إذا جلد الشارب 40 أو أمر حتى ضرب بالنعال وأطراف الثياب. 11209. وأما إذا جلده 80 على رأي عمر رضي الله عنه فمما نذكره في ذلك أن 40 المضمومة إلى 40 غريبة في وضع الحدود والعقوبات، فإن قدرناها من الحد كان محالا، فإنها زائدة على ما جرى في زمن الرسول صلى الله عليه وسلم. نهاية المطلب Volume 15 pages 574-5. ثم يحضر المحبوسين، فمن أقر منهم أنه محبوس بحق رده إلى السجن، ومن ادعى أنه حبس ظلما فالوجه أن يقول: من خصمك؟ فإذا ذكره أحضره وسأله وأمره بأن يبتدي الدعوة وإقامة البينة على ما لا يكاد يخفى ترتيب الخصومة. وإن قال قد حبسه القاضي المصروف فكان ذلك حكما منه وحكمه لا ينقض، قيل له: أثبت حكمه بما تثبت به أحكام القضاة. أما سورة الحبس ليس حكما، فإذا عجز الخصم عن إثبات حق يوجب الحبس أطلقنا المحبوس، ولا تطويل بجعل هذا ابتداء خصومة. 12001. قال القاضي رضي الله عنه: من قال من المحبوسين حبست ظلما أطلقناه، وهذا الكلام حقه، ولكنه خشن في المعنى بالإطلاق أن يخرج من الحبس، ولكن لا يخلى سبيله حتى يحضر خصمه، وفي كلام القاضي ما يدل على أنه يخلى سبيله ولا يتشبث به. ولست أنكر اتجاه هذا في القياس، فإن التشبث به من الحبس فإن ادعى مدع استعد عليه، فإن لا ندري أن ذلك القاضي حبسه بالحق أم لا، وحبس القضاة منقسم إلى حق وظلم وأدب وحمل على تأدية حق، فيحصل مما بسطناه أن ما سار إليه الجماهير التشبث به إلى التفحص من غير أن يراد إلى الحبس، والذي ذكره القاضي أنه يطلق ثم خصمه يتبعه ويستعدي عليه. فإن فرعنا على ما عليه الجماهير قلنا: لو وجدنا محبوسا لا يعرف له خصما فكيف السبيل فيه؟ قال الأصحاب: يأمر القاضي من ينادي باسمه ويقول: فلان بن فلان محبوس، فمن خصمه؟ فإن لم يظهر له خصمه أطلقه، إذا كان يقول حبست بالظلم أو كان يقول لا أدري لم حبست ولا أعرف على نفسي حقا يوجب حبسي. ثم قال الأصحاب: ينادي عليه إلى حد الإشاعة، فإن النفوس تتشوف إلى الطلب إن كان طالب. ثم ذكر الأصحاب أياما وليطاف به، وإنما يذكر اسمه على حد التعريف، وهو في ذلك لا يحبس ولا يخل، بل ينسب من يراقبه ثم يطلق. وهل نأخذ منه كفيلا ببدنه احتياطا؟ ذكر صاحب التقريب فيه وجهين، أحدهما أن عليه إعطاء كفيل، فإن امتنع رددناه إلى الحبس، والثاني ليس عليه ذلك، وهو صحيح الذي قطع به الأئمة. ولو كان خصمه غائبا وزعم المحبوس أنه مظلوم، ولو انتظرنا مطالبة الغائب لطالت المدة والمراقبة أخت الحبس، فهل يطلق والحالة هذه؟ ذكر بعض المصنفين في ذلك وجهين، أحدهما أنه لا يطلق بل يكتب إلى الموضع الذي به الخصم حتى يحرص على إظهار حجته، فإن كسر أطلقناه، والثاني أنه يطلق على الفور، وإذا قلنا لا يطلق عنينا به أنه يراقب، فأما الرد إلى الحبس وإدامة العذاب فلا سبيل إليه. وقد يرى الإنسان في مجموعات الأصحاب عبارات مهمة، ولكن ليثق بما ذكرناه فإن لا نورد شرطا إن شاء له شرطا في هذا المجموع إلا ما نتثبر فيه ونرتبه على نقل كلام الأصحاب وحذف المجازات. 12,002. فإذا انتجز نظره في ذلك تأمل أحوال الأمناء المنسوبين من جهة القاضي المصروف ونظر فيهم وفيما في أيديهم، فإن أمكنه في أثناء ذلك أن يفصل خصومة جديدة شرطة من غير أن يتطرق إلى نظره فيما ذكرناه خلل شرطة فليفعل، وإلا فالبداية بأحوال المحبوسين وبعدها بأموال الأطفال في أيدي القوام والأوصياء الذين صدرهم عن القاضي. وإن استخلف حيث يجوز الاستخلاف في فصل الخصومات الجديدة وتعاطى بنفسه ما ذكرناه من المهمين فجائز. 12,003. ثم اندفع الشافعي في بيان كيفية إدخال الخصمين ورعاية الإنصاف بينهما، فنقول لا يأذن لأحدهما دون الآخر، فإن ذلك يكسر قلب المحجوب ويغلب على ظنه الميل إلى خصمه، وإذا دخل عليه وسلم رد جواب سلاميهما، وإن سلم أحدهما فقد أفرط بعض الأصحاب وقال لا يرد جوابه بل يسكت بناء على أنه وضع سلام في غير موضعه، فإن القاضي في شغل شاغل ولا ينبغي أن يسلم عليه وهو كذلك. هذا وجه. وإن أراد قال لخصمه سلم ثم يرد جواب سلاميهما، وهذا عندي سرف. وإن ذكره القاضي فإن رد جواب السلام محمول على ابتداء أحدهما بالسلام، وهذا مما لا يخفى ولا يظهر ميلا، ثم يسوي بينهما في المجلس ولا يرفع أحدهما على الثاني، وإن كان متفاضلين إذا كان مسلمين أو ذميين، فإن كان أحدهما مسلما والآخر ذميا ففي المسألة وجهان، أحدهما أن يسوي بينهما لما روي أن رسول الله صلى الله عليه وسلم قال يا علي سوي بين الخصمين في مجلسك ولحظك، ويروى آسي بين الخصمين واحد. هذا أحد الوجهين. نهاية المطلب 15,572. Appendix 3. المصالح ضربان، أحدهما حقيقي وهو الأفراح واللذات، والثاني مجازي وهو أسبابها، وربما كانت أسباب المصالح مفاسد فيؤمر بها أو تباح لا لكونها مفاسد بل لكونها مؤدية إلى مصالح، وذلك كقطع الأيدي المتآكلة حفظا للأرواح وكالمخاطرة بالأرواح في الجهاد. وكذلك العقوبات الشرعية كلها ليست مطلوبة لكونها مفاسد بل لكونها المقصودة من شرعها كقطع السارق وقطع الطريق وقتل الجنات ورجم الزنات وجلدهم وتغريبهم. وكذلك التعزيرات، كل هذه مفاسد أوجبها الشرع لتحصيل ما رتب عليها من المصالح الحقيقة، وتسميتها بالمصالح من مجاز تسمية السبب باسم المسبب. وكذلك المفاسد ضربان، أحدهما حقيقي وهو الغموم والآلام، والثاني مجازي وهو أسبابها. وربما كانت أسباب المفاسد مصالح فنهى الشرع عنها لا لكونها مصالح بل لأدائها إلى المفاسد، وذلك كالسعي في تحصيل لذات المحرمات والشبهات المكروهات والترفهات بترك مشق الواجبات والمندوبات، فإنها مصالح نهي عنها لا لكونها مصالح بل لأدائها إلى المفاسد الحقيقة، وتسميتها مفاسد من مجاز تسمية السبب باسم المسبب. 14. Appendix 5. Sanhuri notes that legally valid claims, masali or hukuk, are due to a legal event or a legal doctrine. Masdar al-Hakfi, al-Fiqh al-Islami. Pages 53-4. Sanhuri on appropriating Western legal language by so-called specialists in Islamic law concerning a division of rights into voluntarily and involuntarily had. Correspondingly, duties are voluntarily or involuntarily incurred. Among the most famous first, or in this case second sentences in all of modern jurisprudence, of course, was an answer by Sanhuri to an implicit question. What is a right? And the answer was, a right is a maslaha, which can be translated into a monetary value, and which the law is bound to protect. After precluding public or common utilities and those pertaining to personal status laws, Sanhuri moves to explain that the purported rights divide into person-bound and object-bound rights, as these are known in modern Western jurisprudence. Sanhuri's distinction between hak and ruksa, or a right, and the capacity to have a right, has applications in his discussion of the statutory limitations imposed on certain claims, taqaddum, which Egypt civil law set at 15 years in principle, but put it down to 5, 3, or 1 year in certain matters. The capacity to have rights, on the other hand, never expires. Weighs it 3, 1009. In 1000